everyone. So let's commence with the case law, Sahil Enterprises versus Union of India and GST. So what was the scenario? Let's understand first what was the scenario. The scenario was buyer has paid the tax to the seller, to the supplier. But what happened? Supplier has filed the R1. Supplier has reported the transactions of the buyer in R1, but it hasn't reported the transactions in GSTR 3B and made the payment of GST in GSTR 3B to the government. So authorities asked the buyer that you have paid the tax, but the seller hasn't paid the tax. So the tax has not been discharged to the government on such supplies. Therefore, you have to make the payment of such transactions. Therefore, your ITC is blocked. You cannot avail the ITC on that services on that particular goods which on which the supplier hasn't paid the GST to us. So buyer said, this is not my fault. I have paid my payment to the seller. I have made the payment of GST. I'm eligible. I have the invoice. I have the goods. I have made the genuine supplies. I have made the genuine purchases. So why should I pay? In that case, government said that section 16(2)(c) state till the before going forward, High Court emphasize on the section 16(2)(c) of CGST Act. First, we understand what is section 16(2)(c). That is condition for availing the ITC. Government said you cannot avail the ITC if the tax has not been paid to us. So what is 16(2)(c) states? A registered person shall be entitled to take ITC only if the tax charge in respect of such supply has been actually paid to the government, either in cash or through utilization of ITC admissible in respect of such supply. So in this scenario, the supplier hasn't paid the tax to the government, thus you are not eligible to avail ITC. You have the invoice, you receive the goods and services, you have the invoice reflecting in 2A, but still you are not eligible to avail the ITC since the supplier has not paid the tax. But there comes a catch. Buyer said, this is not my fault. Again he said, this is my bona fide supplies. So government allows it. If you read one by one reading, let's go through the based on 16(2)(c), government said there is a strict interpretation that buyer must ensure seller that he pays to the government, right? But why should I be responsible? I have made the bona fide supplies. I have taken the ITC which is allowed to me. I have paid already. Why should I pay double? Right? I have already paid 100 on my purchases, and I'm taking the ITC of that 100 only. If you don't want to provide me that portion of 100 just because my seller hasn't paid, that will be double taxation for me, right? So accordingly, authorities, the revenue, the court held that revenue, which is a bona fide one, the buyer has paid, the buyer has the invoice, the buyer has taken the ITC basis what the seller has reported onward, right? So it is a bona fide one, so we are allowed to take the ITC. We are not on the default side. This is not the bogus purchase. The genuine purchase is there. The goods are with me. The invoices are with me. So the supplies of that goods, I can on the supplies of that outward supplies, I can take the ITC credit for of the purchases, even if the seller hasn't paid the taxes. That is not my fault. So the section 73 which was invoked, that is non-fraud, is allowed to the buyer and buyer win the case. So this is simple a case of a bona fide supplies. So let's read one by one, line by line of the summary of that judgment. The High Court partly allowed the petition, upholding the constitutional validity of Section 16(2)(c). We have read already with the Section 16(2)(c) of the CGST, right? But read it down to prevent the denial of ITC for bona fide transactions where purchasing dealer has paid the GST to the supplier, right? I have paid to the supplier, even if the supplier fails to remit the tax to the government, like we already discussed this case before, that the supplier fails to remit the tax to the government. The impulse demand order confirming the ITC reversal was set aside, right? What was the summary of facts? Similar. An order dated 17 May 2022, issued by the Assistant Commissioner Tripura, whatever the demand is, and block the electronic credit ledger balance of the buyer only, right? Petitioner, what does buyer's argument in that case? The petitioner, a bona fide purchasing dealer, has paid GST of rupees 1 crore to the supplier, right? There was no mechanism for the petitioner to verify whether the supplier deposited the collected tax with the government, right? How could a buyer could verify that the supplier has paid or not paid? What if he has filed the GST-R3B and we can check over the portal that GST-R3B is filed by the supplier, so we are assuming that this is paid, right? Denying ITC for the supplier's default is arbitrary, unreasonable, voids Article 14, 19(1)(c) and 300 of the relating to the double taxation. What is a core question of law? Whether 16(2)(c) of the CGST is constitutionally valid. If so, whether it should be interpreted to deny ITC to a bona fide purchasing dealer when the supplier has collected but not remitted to the tax to the government. Now let's see what are the key legal issues and findings by the High Court, right? What was the interpretation? The court relied on the principles of reading down the statutory provisions, which was undertaken by the another case law and extensively followed the precedent set by the Quest Merchandising India Private Limited case, which was affirmed by Supreme Court also. Like, first point that is discussed was onerous burden. Section 16(2)(c) places an impossible burden on the bona fide purchasing dealer, right? What was the fault of the buyer? What was buyer was fighting for, right? His right to ensure that selling dealer deposit the collected tax. How should I check now? I said, how should I check? Why should I check and how should I check? Because I have paid, I have taken the bona fide things, right? Next, distinction in bona fide transaction. The Parliament failed to distinguish between the bona fide purchasers who have taken all the necessary precautions, those who have not, stating to the restriction of the ITC solely to the defaulting selling dealers. Avoidance of the double taxation. Denying ITC to the bona fide purchaser who has already paid tax to the seller results in double taxation. Concept not expressly sanctioned by the Act and contrary to the intent of the ITC. Binding precedents from Delhi High Court. Delhi High Court's interpretation of similar provision of the DVAT Act, Section 1992. Binding precedents from the Delhi High Court, that is, the Delhi High Court interpretation of the similar provisions of DVAT Act. Before GST, there was a DVAT. DVAT Act was in the force, which is subsumed in GST itself, right? Subsequently approved by the Supreme Court, serves as the binding and persuasive precedent for reading down Section 16(2)(c). The other high courts' views, while acknowledging that some high courts upheld Section 16(2)(c) without reading it down, this court found their analysis unpersuasive as they overlooked the practical impossibility of the purchases and failed to consider the Supreme Court's affirmation of the Delhi High Court's view. Application of Section 73 versus 74. So, there are two sections in GST, that is, one is 73 and one is 74 for the assessment. But 73 is non-fraud cases and 74 for fraud cases. But as of now, these two are merged into 74A for the fraud and non-fraud both cases. For your general understanding now. Okay, so what is the application as for this case? The court specifically noted that the Assistant Commissioner invoked Section 73 of the CGST Act against the petitioner, which pertains to the tax not paid due to the reason other than fraud. Right? No fraud allegation. The non-invocation of 74, which deals with fraud, because the buyer was not in default, right? He hasn't done any fraud. So 74 cannot be invoked, 73 can be invoked. Next, the supplier's blame. Supplier is responsible for paying the tax which is collected from the respondent, from the buyer. So he has to pay the tax now. Why should I be responsible? Why should buyer be responsible? So accordingly, what's ruling comes that Section 16(2)(c) of the CGST Act is held not violative of Article 14, 19, 265, 300A of Constitution of India. However, it is read down to apply only where the transaction is found to be not bona fide as a conclusive or fraudulent transaction to defraud the revenue. Right? The respondents are directed to forthwith allow kar diya ITC. That ITC is allowed now to the buyer, and the revenue is at liberty to initiate appropriate proceeding to recover the unlimited tax from the selling dealer, not the buyer, as per law. So accordingly, in these cases, if you have done the bona fide purchases, if you have the invoice, if you have the have paid the tax, if the supplier has already reported an R1 and it is appearing in GSTR 2A, then you are eligible to avail the ITC, and no, it is a bona fide transaction. You are allowed to take ITC, and no authority is allowed to initiate any proceedings against you in that case, provided you have taken all other precautions under Section 16C, which allows the conditions for availing the ITC, which provides the condition for availing the ITC, right? Thank you.